We are now about to move into our first, I guess, afternoon session panel, so to speak, or the first of our last two panels, which we are going to have with us today. Before our moderator introduces our progressive IP iconic speaker, and yes, I use that word for you, Maggie. I would just like to quickly introduce our moderator. Her name is Shreyanka Changaroth, and she is the inaugural Wikimedia Race and Knowledge Equity Fellow. And the fellowship is the result of a collaborative partnership between the Wikimedia Foundation, the Institute for Intellectual Property and Social Justice, and the Howard University School of Law. And so, Shreyanka, I would like to invite you that before you introduce our speaker and our illustrious participating commentators, if you would mind just taking a moderator's privilege of 5 minutes to introduce yourself, say a word or two about yourself, and a word or two about what the Wikimedia Race and Knowledge Equity Fellowship is all about, what it's intended to accomplish, et cetera, et cetera.
Yes, thank you so much. I'm really excited to be here today. It's my first time ever at IP Mosaic, and it's been really incredible kind of, attending all the events and hearing about all the scholarship pushing the envelope with that social justice lens in a, I think in a very fairly institutionalized area of law, which is not something that, really bears repeating at this stage of the conference. I think we're all familiar with that. But yeah, as Latif mentioned, the fellowship is it is being jointly administered by the IIPSJ and Howard University School of Law. So I'm working very closely with Professor Matima on this. It's really designed to explore the intersection of racial equity, free knowledge, and intellectual property, kind of finding ways that intellectual property can become more inclusive, equitable, and accessible to everyone, taking apart what we know to be the institution of IP, and especially for the communities that have historically been marginalized and underserved and especially exploited when it comes to reaping the benefits of IP. And this, as many of you might know, is what the IIPSJ does best. And so I will be working closely with them, as well as Wikimedia and experts in the area, both on and off of the fellowship advisory board, which actually Professor Margaret Chon is a part of as well. So yeah, that's pretty much it. I mean, I think that kind of gives me a good segue into what today's panel is going to be about. So yeah, it is. So it's really today's panel is going to be, intellectual property issues relating to access to knowledge and IP's freedom to operate, which is very in line with the aims of this fellowship as well. And if you have any questions about it, feel free to get in touch with me or Professor Matima. So I think with that, I will introduce Maggie really quickly and tell you a little bit about the chapter that she will be presenting. So we have today before us Maggie, or Professor Margaret Chon's draft chapter from her forthcoming book called Improving Intellectual Property, which is what this panel will be discussing. So Maggie will be presenting the chapter titled Prioritizing IP's Freedom to Operate. And now I'm gonna let Maggie do the better introduction and presentation of the chapter, but in short, it critiques the notion that IP rights are the default and takes the position that we can and really should extend intellectual property thinking beyond the market-driven conceptions into kind of considering and incorporating the freedom to operate, which would allow IP to provide not just the existing economic benefits that we are familiar with today, but would then also be able to serve various social welfare, non-economic purposes. And we are arguably seeing an uptake in this like normative push, so to speak, especially in US case law through judicial gestures, which is another key observation made by Maggie in this chapter. So, okay, with that, I think I'll go straight into introducing today's panelists. Of course, Margaret Chon, the Donald and Lynda Horowitz Professor for the Pursuit of Justice at Seattle University School of Law, Colleen Chien, Professor of Law at Santa Clara University School of Law, Brett Frischmann, Professor of Law, Villanova University School of Law, Faith Majekolagbe, Assistant Professor, University of Alberta, Faculty of Law, and Fellow at Harvard University Berkman Klein Center, Julia Jan Osei-Tutu, Associate Dean for Diversity, Culture, and Inclusion, and Professor of Law at Florida International University Law School, and finally, Betsy Rosenblatt, Professor of Law at the University of Tulsa College of Law. So everyone on the panel has penned some really important scholarship that has contributed to our better understanding of the relationship between intellectual property in all of its elements, on the one hand, including creation, innovation, ownership, those elements, but and the relationship between that and inequity. So how this, just to give a little, I'm sorry if the sun is, I just realized. So Maggie will present her chapter for about 10 minutes, and then each panelist will have about 8 to 10 minutes to comment on the topic, discuss it how they wish, and I will be serving as timekeeper. So I apologize in advance if I cut anyone off. After each panelist has had their turn, we'll hopefully have some time to take some questions from the audience. So yeah, with that, I think I'll hand it right over to Maggie.
Thank you so much, Shreyanka, for that wonderful intro, and congratulations on your fellowship. We're very excited about what you're about to do and embark on, and can't wait to see the projects that you end up doing. And also thank you so much to Latif and the Mosaic board for inviting me and allowing me to invite an illustrious bunch of folks to be on the panel. And to my commentators, Betsy, Brett, Faith, Colleen, and Jan, thank you so much in advance for reading this. So as Shreyanka pointed out, the book chapter is forthcoming, and it's part of a larger co-edited volume called Improving Intellectual Property, a Global Project. And each chapter was supposed to be only 4,000 words. So I had a lot of trouble condensing my ideas, but what I hope to do is further develop some of these core ideas into a larger project. And specifically focus on the role of common law, federal common law, that explicitly recognizes and incorporates non-market uses and values within the statutory commodification framework of intellectual property. So let me share my screen here and get into. Can you see it? I'm assuming everyone can see it. So how does, so observers across the spectrum of intellectual property, whether they're considered to be maximalists or minimalists, agree that the competition, free competition, really is the backdrop against which the commodification function of intellectual property operates. And so the market-based IP is very much part of the discourse, but this is trying to engage in a thought experiment of what would happen if we take IP out of this commodification framework. Is there a non-market analog to free competition? And that backdrop is expressed in many ways by many folks, by maximalists such as Landes and Posner, saying competition is not a tort, freedom to imitate, to copy is a cornerstone of competition, and expressed as well by people on the other end of the spectrum, such as Professor Rochelle Dreyfus, who wrote this in a piece that really was trying to expand the idea of users' rights, that competition was the norm and IPR the exception, but in recent years, sort of a Dempsetian view of, if value then right has come to dominate, with the result that the baseline has been to protect all manners of creativity. So I use the term freedom to operate to denote spaces in intellectual property law that tolerate at worst or amplify at best these non-market uses and values that do not impinge or conflict unduly with commercial purposes and uses of IP, and at the same time express really important policy goals, purposes, and values that further the overall progress mandate of IP. And of course, this builds on a lot of work done by others, including commentators on this panel. So in many ways, this is not a new project, but I think what is arguably underexplored is the role of the courts, and specifically doctrine developed outside of the statutory frameworks or treaty frameworks, or within perhaps some of the ambiguous gray areas of the interstices of the statutory text. So here's some examples from copyright. We have the quotation from Justice Breyer's opinion in Google versus Oracle that there might be a risk of creativity related harms to the public, which is really coming from his analysis, the court's analysis of the fourth fair use factor. And the fourth fair use factor does not address non-market harms. It really pertains to potential harms to the market for the copyrighted work as opposed to harms to the public. Another quote from Kurtzang, another opinion authored by Justice Breyer, looks to harms to the public, again, through the application that would happen if Section 109's first sale doctrine did not apply to goods originating outside of the United States. And here we also see a typical strategy from courts, by courts, to rely on the progress clause of the Constitution to really justify this regard, this turn to non-market harms and public policies. Again, of course, the court has repeatedly recognized the importance of expressive freedom and breathing space in the fair use doctrine, is exemplified by the transformative use doctrine, which to some extent might be reconsidered in the current Andy Warhol case, but has really taken a very large role to the extent that bakers at Costco are even talking about it now, as we talked about. And then in the patent space, the doctrine of exhaustion in patent law is a judicial carve-out to the patent statute. This is a nice quote from Justice Roberts in the Lexmark case. Subject matter exclusions, the Alice Mayo duo, excluding laws of nature, et cetera, from Section 101, again, not grounded at all in the statutory text or in any stated purpose of the Patent Act. And then the longstanding doctrine of repair, which the court enunciated as early as 1850 in Wilson versus Simpson, again, not tethered to any statutory language. So what we're seeing is a number of non-market uses and values being expressed not only by scholars, such as the scholars who are assembled here today, but also by courts. And that's often expressed, these things are often expressed through terms like the public domain, public interest, public access, the public good. But I think they also go to the question of what is the overarching purpose of IP, which Latif and others have talked about, is really to advance social justice and social welfare in a more egalitarian way. And these terms, public domain and public interest, while they're very powerful, they don't really do that nuanced work of sort of expressing or representing the sort of activities and uses that people have to engage in order to express things like, happiness, joy, play, private enjoyment, and so on. And note that not all of these non-market uses actually would go in the direction of freedom to operate. Some of them would actually bolster, the imposition of exclusive rights, things like the right of attribution or the right of integrity. And we can talk about that more in the Q&A, but I would argue that most of them actually weigh in the direction of so-called freedom to operate. And I want to just, as an aside, say that this term freedom to operate that I'm kind of co-opting from its narrower definition in patent law is important. I'd like to use the term freedom to denote, for example, to allude to development as freedom, but also to denote to perhaps those of a libertarian tendency, that there is a very important underlying freedom that forms the backdrop to the exclusive rights, right? Not just free competition, but freedom in other senses. And we see this coming through loud and clear, I think, as clues in the common law doctrines. For example, in fair use, which has done the brunt of the work in this space in copyright, or even secondary liability to some extent, although that tends to reinforce exclusivity. But we see common law doctrines that have been incompletely codified into the statute, which the courts then run with, right? And Congress has actually expressed that it wants the courts to run with fair use and continue to develop it. But there are a lot of doctrines that appear to be based not at all on the statutory text. And that includes, for example, not only things that I discussed in the previous slides, but the faculty exception to the work for hire doctrine in copyright law, the government edicts doctrine that was discussed in the Georgia versus Public Resources case in copyright law recently, the doctrine of assigner estoppel in patent law, which was in the Minerva case, again, a recent case, the doctrine of experimental use in patent law. And all of these are pretty much untethered to anything that Congress has actually spoken to. And note that, courts will often, and almost always, I would say, couch their decisions, again, in the language of the progress clause, which suggests that there's something missing in the enunciation or articulation of the overall purpose of IP. So after I completed this chapter, I revisited Sean Balganesh's institutional settlement framework, where he describes how there was a mid-century shift in viewing intellectual property mostly as a system of internally consistent rules, which originated, of course, in the legal formalist period, so the Langdellian period, but even persisted throughout legal realism, that it was sort of internal consistency and coherence that mattered, and that Congress's, Congress, the statutory text was less important. But during the mid-century, he argues, and I think very persuasively, that there was a shift to a legal process approach propounded by very influential scholars at Harvard. And that's characterized by the primacy of the statute. That's what we see today, that the statute is the starting point, and that we have to think about or ask, what is the purpose of the statute? What is the policy as manifested by Congress? Once you do that, then the secondary question is, how do courts further that policy or purpose in the face of the statutory text? And, the big question here in my mind is the statutory text all-inclusive? Is it exhaustive in stating these policies, or are there important underlying IP policies and purposes not manifested in the statutory language? And that's, again, where we see the courts continually falling back, not on the statute, but on the progress clause. And courts are in this institutional settlement framework. They do have a role as institutions, as part of the three branches, right? But, Balganesh also talks about the Copyright Office and agencies having a role in this idea of effectuating the purpose of intellectual property. So it's not just Congress, it's not just courts, it's not just agencies, perhaps, idea entrepreneurs like professors, but it's really all these institutions that sort of are supposed to work together. Nonetheless, the big shift here is that in the mid-century, from not really taking the statute as a starting point to now what we do, which is really seeing it as primary. And he also points to this idea of copyright policy or IP policy more generally is really originating in that mid-century moment. And here's a quote that he attributes as to one of those founding moments where policy is explicitly expressed in scholarly works or in court doctrine, right? Here in 1958, the balancing of the incentive to artistic creativity against the resulting burden. So we're so familiar with this balancing test now as, sort of a policy test, but we tend to forget that it wasn't always there. It was really actually sort of born within the legal process sort of moment or movement. So the other thing in my paper that I think really aligns with recognizing non-market uses, of course, is the capabilities framework, which Jan has worked on, which I have also worked on, which Faith mentioned, which derives from this idea of development as freedom, and that the purpose of IP is not just for innovation per se or commercial success per se, but for human flourishing, right? And if we recognize that as the underlying purpose of IP, then we have to give more weight, whatever the institution is, to the benefits associated with experimentation, learning, repair, and other non-market uses. And I argue, and others argue, that's more likely to result in the realization of overall social welfare rather than the sort of lopsided winner-take-all sort of approach that we seem to have with market fundamentalism. And what happens, in our current system is the focus on commercial success per se results repeatedly in the invisibility of these important non-commercial uses. And so the term again encompasses as an umbrella many of these important uses. But the question is about how much weight to give to the statute and recognizing that the statutory purpose is incompletely expressed. So one of my colleagues who teaches con law, and her area is labor and employment law, which is also a heavily statutory area, sort of referred to this as a constitutionally inflected statutory interpretation, where it's interesting that the Progress Clause drives so much of this articulation of freedom to operate. So there are lots of challenges to operationalizing this idea of freedom to operate. We know they're pretty familiar, the incentive theory, which is really dominant right now, even in opinions that are trying to articulate something other than market-based analysis, they usually do frame their rhetoric in this sort of commodification language, and it makes it very difficult to actually pull apart the commodification from the non-commodification benefits and harms. And, last but not least, most importantly, perhaps, there's a perception that courts are going beyond their legitimate institutional roles, which I argue they are not. So last summer, there was a big fight in the American Law Institute, the ALI's restatement of copyright meeting between those like Balganesh, actually, who championed the primacy of the statute and really questioned the role of other institutions like the ALI and even the courts to explore and engage with flexibilities in the Copyright Act. And I actually started out with a strong claim in my chapter, and I kind of walked back from that. But the claim was that the exclusive rights in the statute are actually abrogations of sort of a more fundamental, pre-existing sort of freedom to operate. But now I think my claim is that the statutory purpose is just incompletely expressed. And it is the legitimate role of courts to actually express the full purpose. And we know that because the Copyright Act, for example, is a product of compromise and industry compromise, as Jessica Littman pointed out. And it's also, sort of a really good example of regulatory capture. I think Peggy Radin once said, this is the best example of regulatory capture in any place in the US Code. And that might be a very accurate assumption. So very quickly, I'm thinking about how this might actually relate to other areas that don't have a constitutional clause that promotes progress, but there's still a room to amplify open-ended provisions in existing other statutes as well as treaties. One effort to do that is a recent book by Tanya Aplin and Lionel Bentley, who argue that TRIPS Article 10, which Faith talked about earlier, actually mandates fair use to member states. There have to be fair use provisions based on the quotation language in Article 10. One other possible approach that could be used beyond the United States and also within is to leverage the purposes and objectives language or articles in various treaties or other statutes to expand, for example, our constitutional language and our understanding of it, noting, of course, that it's not based on the Commerce Clause. And so that's a pointer in the direction of non-commercial purposes and values. And then possibly amending or enacting statutes or treaties to enhance recognition of non-market factors. And we see an example of that recently with the Marrakesh Treaty. And there are other possible approaches that could enhance and amplify, I think, this idea that I'm working on. But I'd love to hear from the rest of you about how you think this intersects with other aspects of Latif's and Mosaic's sort of overall goal, which is to help marginalized communities experience some of the benefits of IP. So thanks so much for your patience in listening to this. I'll stop sharing, and I really look forward to the discussion.
Maybe we'll start with Colleen, but before that, I just wanted to ask, I think, Latif or Kaylee, do you know what time because of the delay, what time will this panel finish?
Yeah, just get my camera on. Yeah, just so add 5 minutes.
Yeah,
So
okay,
we'll,
that's
yeah,
yeah.
to the end time. Okay.
Okay, thanks. So maybe we'll start with Colleen, and then yeah, you can go ahead.
Great, thank you so much. It's just terrific to be here. Thank you so much to Shreyanka and Latif and the organizers of this conference, and to Maggie for the gift of this chapter and the ability to comment on it at this early stage. You know, I'm actually actively working on work that builds upon Maggie's work, foundational, on helping us rethink progress from a while ago, which spawned many conversations, and I think follow-on works by many of us. And I'm excited to sort of be at the beginning of this, I think, new conversation that she's starting by thinking very deeply about freedom and how it really should be more centered in the IP policy and purpose conversation. And so I'm excited to be sort of at the forefront now to be able to comment on this. So I just want to comment on a couple of things that came up in my mind reading through this, and they have to do with trying to think about what the nature of the freedoms that you're talking about are, and how we kind of connect freedom to operate with, more specifically, what freedoms what that looks like. And I think one challenge I have is thinking about distinguishing between non-market and market freedoms. I'll talk about that in a minute. I want to then talk about the question of how we get these freedoms, because I think that in the shorter treatment, there's not as much exploration of that, but I think that that's a very central question to this community in particular. You have to sort of go through a 4-factor process to determine whether you have a freedom to operate versus if you can get it through a very clear statutory or other exception. That's very different, and that means it has different implications for who can access that freedom. And then I want to talk a little bit about, if we have time, this kind of question of what freedom from legal enforcement really means in a world which is very unfree in other ways, in terms of other resources and things that are actually needed to exercise that freedom. So just 3 ideas, and I'm happy to sort of elaborate more, but I'll try to keep my remarks fairly brief. So I think the first question around the nature of freedom is really important, because you talk about freedom to operate, and in my intersections with my work, I'm primarily a patent person. I think the freedom to operate concept has been extremely important, but it has been, I think, in a more, I struggle to distinguish between the non-market and market uses of that freedom. So I think freedom to operate more generally, we think about as the ability to innovate without worrying about liability that comes from it, and the accumulation of patents by various actors to get that freedom to operate has been a very central and maybe the primary reason why many companies get as many patents as they do. I think closely connected to this is the freedom from bullying, which I think is still a market-based. I would say is freedom to operate in the first context I mentioned. Often is in it to advance a commercial interest. I want to be able to copy and take different ideas and come up with my own ideas without having to worry about enforcement of others of IP, so that I can sell more products. Freedom from bullying is similar, where you have the same dynamic, but it's with a larger player, going after a smaller one. And I think a lot of the patent troll questions and debate was really centered on the freedom of small defendants to not have to deal with large lawsuits and to deal with the high costs of defense that they were confronted with when they were sued. I think separate from this is sort of the idea of freedom to play. And there, I think, I don't know if we would see it as much as in the patent space, but certainly in thinking about the public domain more generally, the freedom to really explore and to not really be encumbered by having to really account for which IP rights you might be coming across. I'm thinking a lot about Jessica Silby's work, which I think much draws on yours, but in her recent book, she really talks about this freedom as being very essential to be something that we want to protect, which I would see as more non-market. But in that vein, I think there's this kind of enabling environment on the patent space, again, of freedom to share, And then also freedom of expression of what happens to works that I create that are patentable. So with freedom to share, I think about, again, works around pledges and licenses and the ability to disseminate the work and to hold it back in certain circumstances to let it forward in others. And I think that goes to a freedom to be able to express precisely what I want. What's my intention for this work? How do I, say to the world, well, I might want to exclude it in certain ways. We know with patent terms, you can specify how long a patent is in force. You don't have to have it be one fixed term, but even what particular uses might be acceptable, which ones might not to me, but to be able to freely express in precisely what I want to do with innovation is, I think, part of what we're also getting at. But again, I wonder if it's more about the actor, if IBM is doing this with their patents, it's always going to be in service of something commercial. Do we consider that to be a market use? So is it based on the actor, or is it really about the actual action? I think that's something that I would try to push on a little bit more. And I think this raises the question of how we get to this freedom next, because a lot of the mechanisms of how you get freedom to operate or freedom from bullying, et cetera, are different, right? It's not only the case that you might get it as a baseline by a Supreme Court decision or by an exception, but it might be a position that you get into vis-a-vis, say, the high cost of enforcement. The high cost of enforcement, the probabilistic nature of rights means that in a lot of cases, there is some level of freedom to operate without worrying too much about a lawsuit if you're sort of staying under the radar. Private ordering responses are a different type of mechanism to get us our freedom. But as I said before, it might be really difficult to administer, especially for those who aren't as resourced, to understand, oh, I actually do have the right to use this because there was a pledge that was made on this date in this place that gives me the ability to do this because I fall under the exception that has been specified. I've mentioned before that freedom can be the consequence of détente and mutually assured destruction, which is about accumulation, right? It's about getting lots of patents on both sides. So that's a completely different mechanism. Or are we really talking about freedoms that are absolute, that are not contingent, that are in some sense true freedom? And that brings up the next point, which again, I'll end here and sort of raise the other points later, just to make sure I don't overuse my time. But the question of what is the nature of the freedom that you're talking about? Where is the legal right really the essential thing that provides the freedom, right? How do we identify those circumstances? Because freedom to legal enforcement, from legal enforcement, in a world where the exercise of that freedom requires resources, requires education, requires time, I think is something that we need to consider in context. Stephanie Baer's work, Poverty and IP in particular, comes to mind, where she talks about scarcity, the scarcity mindset, which precludes the ability to actually respond to the incentives of the intellectual property system. We might have the system, this incentives, we might have the rewards, but the basic material there to actually innovate and to have the space, the freedom is lacking. So I just sort of question how we think about these, where it is really essential and where it really will create freedom when we have these sorts of expressions of freedom, and again, where there is a large pronouncement where institutions can make complete decisions, right? We think about Supreme Court jurisprudence and diagnostics, then you do see the freedom as completely enabling. And so what does that mean for thinking about it from a social justice lens? Where is the imposition of information or of IP rights really limiting activity? I think that's where we want to focus on ensuring that the mechanisms to make sure that those new freedoms or freedoms that might be created are well communicated. So I'll end there. Thanks.
Thanks, Colleen. Okay, I think we'll just really quickly move on to Brett, if you wanted to go next.
Okay, sure. Can you hear me?
Yep.
So let me just say what an honor. It's so grateful to be invited to be on the panel. I still remember when I went to my first IP conference ever as a professor, and I went to Michigan State for one of Peter Hughes' conferences, and I got off the plane and I walked out and I was like lost, and I must have looked like Bambi or something, like wide-eyed and didn't know what I was doing. And Maggie came over and said, "You look lost." And I don't know if you remember this, Maggie, but put her arm around me and like took me like, let's get a cab. Are you going to the conference? We'll get a cab together, and like took me to the conference hotel. And anyway, I just still remember that. I don't know if you remember, Maggie, but I always remember, and I'm just so glad that I'm here, that I'm where I am today, and that I met you, and that like you've influenced a lot of the work I've done, and it's pretty cool to be on a panel talking about your work. So anyway, thanks. Let me just say, like, for me, the overwhelming vast majority of information, knowledge, product of human intellect that matters in the world, that exists today and that has ever existed, is generated and shared outside of IP-enabled markets and without government subsidy. Okay, so I think you're 100% right, Maggie, from the very get-go, to emphasize that defaults matter, and the relevant default for thinking about intellectual property systems, whether copyright, patent, trade secret, whatever, is as exceptions to the default. That the default is a freedom to operate, that we as human beings in human society generate and share knowledge, experience, information, common sense, all kinds of things that matter and have mattered over time across generations and different cultures and etc., without the need for intellectual property enabled markets. That doesn't mean intellectual property enabled markets aren't super important in generating certain kinds of things that might not otherwise be sustainably produced and distributed in scale and whatever, and that matters. But I think you're right to emphasize, to re-emphasize sort of revisiting that basic default. So I just wanted to open with that, to just say, like, as a refresher, just if you think broadly about the kinds of things we're talking about, you can see why this paper is so important, right? So then I want prioritizing IP's freedom to operate. I think it's just a great paper. It's a great start. I strongly encourage you to keep going with it, because I can't wait to see what comes next. As Maggie's argued for many years, IP is and should be about enabling human flourishing. And that necessarily entails recognizing, supporting, and valuing individual and social dimensions of human development. We could think like sustainable human and intellectual development, or sustainable human development, and what that entails from a knowledge perspective. Economic and non-economic factors matter. Market and non-market values matter. It's hardly contestable that all of those things matter to human development. Progress is not and should not be conceptualized as some predetermined linear path, right? As a road paved with more and more commercial products and innovations to destinations that are imagined exclusively by venture capitalists and other market actors. Rather, as Maggie and others have sort of emphasized, progress in science and useful arts is open to many reasonable interpretations, even within a consequentialist frame. And Mark McKenna argued that in a recent article, building on Maggie's and plenty of other people's work. But there's at least a dozen plausible, perfectly reasonable, consequentialist versions of progress that we might care about that don't entail creating many more and more, like the quantity of works of authorship and inventions isn't the relevant benchmark. Choosing what path depends on deliberation, choosing among values and priorities and comparative institutional design. It is and should be contestable. Deference to overly simplistic economic theories rooted in toy models of markets and society don't help us and only lead us astray. And again, I agree with Maggie, as she explains in this paper and in others, that human flourishing in the Aristotelian tradition, reflected in human development and in the capabilities approach, provides a rich, normatively attractive set of shared values or ends to aim for. This is actually the thesis of an article I published in the review. It's like one of those hidden articles that, like, it doesn't come up on Westline or anything, but it's in the Review of Economic Research on Copyright Issues. And it's called Capabilities, Spillovers, and Intellectual Progress toward a human flourishing theory for IP, for intellectual property. I might go to the piece in detail, but I hadn't thought about that piece in a little while until I read Maggie's piece, and it made me go back and just like, oh, I forgot about that piece. I wanted to return to it and keep going with it. And so I was like thinking about the two in tandem. It does provide plenty of support for the theoretical case that Maggie makes. The first and second parts of that article jibe rather well with sort of the critique of incentive theory and economic theory. There's also, I think, a bit of a critique of capabilities theory worth bearing in mind. Like there's certain critiques in that literature that highlight some problems you might run into when you try to extend it to IP, and that's worth just taking note of. But I really think the third part of the piece might be the most relevant for us, or at least if we keep going. I was thinking like as this paper develops into more work, because it focuses on legal means for supporting and enhancing capabilities. And I'm just going to talk real quickly about three ideas that I think, and I'll be very quick about these, but the first is the idea of moral floors for states. The second is social obligations on owners embedded in IP laws. And the third is a plea for functional analysis and comparative institutional design when we're talking about IP laws, that you can better account for the interdependent relationships between people, resources, and actions. So on the first idea, the moral floors for states, you can kind of look back at Nussbaum, and you referenced this to Nussbaum, Martha Nussbaum's work, where she has a list of the 10 basic capabilities: life, bodily health, bodily integrity, senses, imagination, thought, emotions, etc. And this gives you a sense of like why the freedom to operate and other related freedoms might matter, which maybe goes to the point that Colleen was making, is thinking of the variety of different kinds of freedoms we're talking about, and their freedom to pursue, their freedom from and their freedom to, first of all, but they're also freedoms that are connected with access to resources so that you can actually choose certain capability, to exercise certain capabilities in life, to pursue certain functionings, as Sen would call them, but to, affiliation being another one. But I think thinking about the relationship between these I should say, is the way that Nussbaum thinks about these are they're goals that every state should have and be held to, though they're very ambitious. So you might not reach them, but they're moral floors. So when we think about the design of intellectual property systems, we should think that these are moral floors that ought to sort of think how we shape how IP systems are designed. And that might be useful, I think. Might be, I don't know, we can talk about it in Q&A, but I think it might be a useful way to sort of push on moral obligations that we think states ought to bear. Maybe embedded in human rights treaty. It might be also a way from the international angle to tie human rights obligations to intellectual property treaties and obligations as well. The second idea of that is drawn from Greg Alexander's work in property theory and a social obligation theory of property law, which he builds on Sen's work and capabilities approach, and he kind of narrows the set of capabilities. But he basically talks about certain social obligations on owners by virtue of the fact that they've taken advantage. Like if you're going to rely on and take advantage of the property system and the property rights, which gives you a capability to sort of certain capabilities that enhances of your own, you owe certain obligations to the rest of your community, to society more generally. And in the context of intellectual property, you might think, part of the reason the nature of this social obligation is tied to the nature of the resource, the excess capacity or non-rivalrousness in the resource itself. And so if you leverage non-rivalry, the non-rivalrous nature of knowledge resources, by the way, I disagree with Stern in a little footnote. We could talk about that on the side. That's easily dealt with, but it's not right. Anyway, leverage non-rivalries, take advantage of the extra degree of freedom the resource gives you. Knowledge resources give you an extra degree of freedom in how we manage, share, operate, govern, propertize, whatever. And that extra degree of freedom is where you can you've got wiggle room in terms of institutional design. And so that's where you might embed social obligations on owners to help enable others, community members, so that they have the freedom to operate. I think there's a thing there to pursue. And then the last thing I won't dwell on because I'm talking too long and I tend to do that, which is just this idea that and you said this, like the overall simple, you have to be more nuanced, and the nuance comes both in terms of institutional design, but also in terms of the nature of the resources we're talking about. It's not just that they're public goods, it's that they're public goods that are often infrastructural in certain ways, meaning, as you say at one point, like they're inputs into lots of different things that people can do. And the wider the variety of things people can do when they can access that low marginal cost, usable resource, that's another degree of freedom that you can take advantage of when you just think of designing IP systems. So like, in other words, the more generic the thing is, or like in the abstract ideas or in the idea expression doctrine, if we think about, these in both places, the more sort of generic something is, the more freedom we have to enable people to have a freedom to operate, to use it. And so we should leverage that when we can.
Sorry, Brett, I think I'm gonna have to cut you off there. Maybe we have
That's
some
awesome.
time during
That's
Q&A.
I need it. Thank you. Just need it. Thank you. Sorry, I rambled. I just love it. It's good stuff, man.
That's okay. I do want to try to give some time at the end of everything to kind of, give the floor to audience members, but we are running out of time for that. So I'm just going to move straight on to Faith. Thank you, Brett. You have the floor, Faith.
Thank you, everyone. Thank you, Maggie, for inviting me to comment on your paper. Many of you may not know, but Maggie was my PhD external examiner, and it's such a privilege for me to, comment on Maggie's paper, which many of our works influenced my own direction in my thesis, and also I was very grateful to have her read my own thesis. So I think my comments would be on mainly on whether I view judgment law as favoring access over exclusion, and also looking at what the scope of the freedom to operate, and also grounding it in Amartya Sen and Martha Nussbaum's idea of human flourishing, and also Amartya Sen's idea of freedoms and unfreedoms. And so I would comment on both bits. And so I think all over in the UK, in Australia, in Canada, and also in the US, we're seeing judges really favor exclusion over access, even when the copyright laws tend to favor access over exclusion. And for me, who has always viewed courts as the last hope of the common man, especially when you grew up in a place where there are lots of extrajudicial things happening, and the courts tend to be the safeguard. So I view this idea of courts also, favoring exclusion over access, as courts saying, oh, we are still the last hope of the common man. If the legislature would favor our copyright lobbyists, we are going to preserve the public interest in copyrighted works. So I'm more familiar with cases in Canada, and in Canada, even though the Copyright Act does not talk about the balance between protection and access, although you find some exceptions to copyright law, you would find Canadian courts talk about the copyright balance and how the concept of user rights, which the Canadian copyright law does not use, but the Supreme Court of Canada recognizes exceptions to copyright laws as not just, privileges that are given to copyright owners, but they are rights that are accorded by law to users. And also looking at, a recent case that was decided in the summer, where the Supreme Court, again in Canada, emphasized the fact that the overarching purpose of copyright law is to balance authors and users' rights by securing just rewards for authors while facilitating public access to works. Again, that's not something you would see in the Canadian copyright law, but that's a lens from which Canadian courts have interpreted Canadian copyright law, and that's a lens from which they've also justified certain uses that are being made of copyright works that copyright owners really want to exclude users from making use of copyrighted works in those manners. And in terms of also thinking about the role of judges and what the judiciary does in promoting that free space within copyright law, or this idea of freedom to operate. And Maggie, you were talking about this global approach. I was also looking at it from the perspective of also developing countries, and also the role of the World Intellectual Property Organization. So why I find that judges in the West try to favor access over exclusion at least in Nigeria and some West African countries, it's not necessarily the same. Judges tend to focus or favor exclusion over access. And I have been examining like WIPO documents and some of the capacity building events that WIPO has been doing for organizing for judges in that region. And I have seen an emphasis on IP enforcement when our WIPO is training judges in developing countries and emphasizing exclusion and not really reiterating that balancing that we must have within the copyright framework. So in thinking of the global space and thinking of how judge-made laws can further progress that free space within IP law, I think we should also be thinking about capacity building and WIPO's influential role over judges in developing countries. And also from the international perspective, and also looking at talking about international norm setting to create these free spaces in international law. Also looking at the role of international human rights and whether this idea of freedom is something that is very connected also to human rights. And the most recent international instruments that favored access over exclusion, the Marrakech Treaty, was kind of built upon international human rights and the rights that persons with disability have. And that was the premise upon which the word blind union really argued and promoted and fought for, if I may say, for the Marrakech Treaty. So international human rights law may also help us to, I think about how we can incorporate those free spaces within corporate law. So in terms of the freedom to operate and the scope of the freedom to operate, I was thinking about what should be the scope of the freedom to operate. Will all non-market uses fall within the scope of the freedom to operate as you're thinking about it? And also when we talk about like non-market uses and freedom to operate, why is the freedom to operate essential? I know you've spoken about human flourishing, and I was also thinking, and I think it was Brett that said it, that perhaps tying it to the capabilities for human development, and also tying it to the role of intellectual property in the Sustainable Development Goals, which are basically the aim of the Sustainable Development Goals, at least as the UN says it, is to make sure that everyone in court has the freedom to develop. And so maybe looking at those 17 goals, which I know that in your edited book, you looked at that, so may also are helping grounding or expanding on why the freedom to operate is essential. Thank you very much, Maggie, for the privilege to contribute and to join this amazing panel.
Thank you so much, Faith. Okay, we'll move on to Jen.
Okay, great. Thank you. So let me just start by saying that I'm also delighted to be able to comment. And Maggie, of course, has been so influential for so many of us and has been generous in terms of her time as well, and is just amazing. So it's an honor to be here. I'm going to try to be pretty brief, and I'll probably be asking more questions than commenting, but I've really enjoyed this so far. And even just I was saying to Brett, as he talked about social obligation, that I thought, oh, right, I started writing about that and let it sit. So maybe I'll go back to it, which is the great thing about Mosaic. So I'm just going to talk about three things. One is the relationship between sort of the international and the national in the paper. I'm going to speak about the freedom to operate. And finally, I want to talk about this idea of couching IP in the language of commerce. And so some of what I say might repeat some of what others have said, but I hope that will just make you see that people are thinking about the same thing when they read the project. So I really love this idea of the freedom to operate. I think it's a really great concept. And it did remind me, as I was reading, I was thinking, is this about, Sen's idea of development of freedom? Is it building on that? But then I thought it strikes me as slightly different, and perhaps this is more of an IP specific issue. Maybe it's more about the core within the IP balance, the space that exists where there's respect for IP, but also respect for the freedom to operate. So I don't know if I'm interpreting that really accurately, but that's one of the things that I was curious about, what this freedom to operate is exactly. So I'm going to start first with the international national, which is where sort of my scholarship comes in. So here there's a focus on US law, but there's this reference to a global principle of a freedom to operate. And for me, this is where it interacts with my research on traditional knowledge, and the sort of the movement that we're seeing internationally in terms of protecting things like traditional knowledge and seeing recognition for traditional knowledge even in trade agreements like the Comprehensive and Progressive Trans-Pacific Partnership, the CPTPP, and also in places like RCEP. And I was wondering if you have started to think about how much you see this idea of the freedom to operate as something that will be pushed by external forces. Is it going to be something that is driven in part by international activities, right? Where we're saying we're going to protect TK, or for example, in the CPTPP, where they talk about corporate social responsibility, or is it something that you see more as being internally driven? Is it something that's more likely to be internally driven, or that already exists in the US? So I'm wondering about that sort of national, international dimension. The other thing I wondered about as I was reading this is, how much you see freedom to operate as something that would be influenced by non-IP activities and non-IP models. So, I'll come back, for example, to corporate social responsibility. Somebody else mentioned human rights, I think environmental social governance. How much are the shifts there, and the way that those areas are growing and gaining recognition, how much might that affect IP's freedom to operate? And then I really wanted to know more about the scope of the freedom to operate. So we've heard about the different things that could be freedoms, and the idea of the freedom to operate makes sense to me intuitively, but I'd really love to see more about how the boundaries are defined. And as I was reading, I thought, is this a natural rights approach, or it's not really a natural rights approach? Because, earlier on in the chapter, you talk about the idea that the freedom to operate, that the statutes are a barrier. And so I thought, if the statutes are a barrier, is this something, so it's before the statutes, is she talking about natural rights? Or is this really an idea that, whether it's natural rights or a consequentialist approach, that we need to prioritize the freedom to operate, and you're not really going to get into that natural rights consequentialist debate? And then I also wondered, are you talking about, is the freedom to operate limited to non-market considerations, the kind that you discussed on page 4? Is the freedom to operate for users, or would creators of IP protected goods also be able to claim the freedom to operate? So like, could a trademark owner say that their freedom to operate is hindered if their marks are not respected, for example? Or is this really about access rights? And then it's, aligning with the scholarships on exceptions and limitations, or is it something else? And the way I read it, I thought maybe it's actually something else, because towards the end of the chapter, you say that that non-market considerations may lean towards enforcement, which suggests to me that the freedom to operate is not, you're not talking just about access. And so that I'd love to see that further developed. Like, when does it tilt towards enforcement? When does it tilt toward against enforcement? Like, is freedom to operate itself the guiding principle, or are there other guiding principles? Because you talk about human flourishing paradigm providing the theoretical foundation. And I thought, well, that also aligns with the scholarship on IP and human rights, but which could tilt towards access or against access. But I'd love to see this developed further, and for you to really make the other explicit the more explicit connection to human rights, or say that's not really what it's about. And I'll confess to you, I find that, when we talk about sustainable development and human rights and human flourishing, it all sort of blurs in together. So we just heard Faith talk about sustainable development goals, but then how does the freedom to operate fit with all of that? And then lastly, and I think this, for me, I'd really love to see more about this, because I think this is such a critical point. You talked about so talking about judge-made law, you talked about couching IP in the language of commerce. And I just would love to see this teased out. So like when you talk about courtesing, you say it's couched in the language of commerce. And I think much of what is done in the IP space is couched in the language of commerce. So for instance, I was looking at the Indian Arts and Crafts Act and kind of looking at the history behind that. And it's this sort of truth in advertising type law where, they say you can't represent something as coming from a federally recognized Indigenous group if you're not from that group. And I thought, okay, well, this is like a dignity interest there, but it's couched in the language of commerce, right? They say it's all about allowing the Indian tribes to develop economically. And so I thought it'd be really great to actually tease it out, because as Trevor Reed talked about yesterday, there are clearly non-economic harms at issue. So when we have IP justifications or court decisions that are couched in the language of commerce, where do we find concrete support for it not really being about commerce? Is it, can we just say, well, let's focus on the harms identified, which is what I think is part of what you're doing in your paper. But I would love to see that developed further, because I think that there's so much about IP that is couched in the language of commerce. And we know it's not all about commerce, but how do we really strongly make the case that no, that's not really what it is, when they're saying, well, it's about the commerce, then they refer to other things. So, but I really love this. I really want to see it developed further so I can draw on it for my further work. So thank you.
Oh, thank you so much, Jen. Okay, we're going to move on to our last commentator, Betsy.
Thank you. I feel immensely privileged to be in this company. I feel elevated by my panel mates, and really honored to be in this group, and also really quite honored to be the kind of mop-up pitcher here, or whatever the word is, because I think part of what's so fascinating about all of this is how each one of us has had something really distinct to say about this without having conferred with each other before. And that may just be the art of putting together a panel, which I gather Maggie did, but also I think just a testament to the richness of this idea. Because as I was reading at first, my initial reaction was like, yeah, this is all obvious, sure. And then as I started to think about it, I started to realize that the stuff that may seem obvious to me as I'm reading seems obvious because I agree with it, not because it's inherently obvious. And it actually needs to be fleshed out and discussed and explored and foregrounded. And one of the things that I think is not inherently obvious, but that this piece does, is recognize that there may be an inherent tension between commerce and freedom. We think of commerce and freedom as sort of American values in the large sort of flag wavy way, and they're not necessarily consistent with each other. And I think that we need to kind of recognize that to even get past step one of this theoretical journey. It is not obvious, I think, to connect freedom to operate with non-market benefits until you sit down and think about those tensions between freedom and commerce, and the extent to which commerce sets up and reinforces and reifies existing cultural and sociocultural hierarchies. And until we get to that point, there's actually, it feels easy to say freedom to operate is the same thing as freedom to get rich. And they may not be the same thing. And so we have to think about that. So I think that non-market benefits accrue in the act of creating innovation to the people, the people engaged in the act of making and people engaged in the act of using and everyone in between. And it is clear to me that there's actually very little distinction between those two categories of people. Now, I'm a hardcore dialogist, so of course I think that, but making and using are part of a cycle that is itself inherently rewarding. And the non-market benefits that we're talking about, in many ways, I think, depend on our recognizing that there's very little difference theoretically between makers and users in that value structure. And once we do that, I think using the framework that you've set up enables us to do a thought experiment that I think a lot of us have tried to do without that kind of theoretical framework overgirding it, which is to ask, what would a system look like that prioritizes non-market benefits? And I have some brainstorms on that. What would a system look like that prioritizes non-market benefits? It would still have incentives. It would still have governances. It couldn't do without those things. But it would pick different winners and losers, and it would have different bases for picking those different winners and losers. I think it would have an opportunity to foreground social justice concerns explicitly in ways that a purely commerce-focused approach cannot, because you have to go a long way around to get to the social justice by way of commerce. I think it would recognize that positive law is positioned in the shadow of norms. I mean, this is following up on what Brett said and on all the work he's done about knowledge commons, but also work that I happen to be thinking about a lot right now. So of course my head is on it, that norms govern what we do far more directly than law. And a system that requires turning people into plaintiffs and defendants is not the system most people are going to think about, and not the system that's perhaps best enabled to think about non-monetary benefits of being a user and a creator. I think that a system that prioritized non-monetary benefits would also prioritize infrastructure. It would be highly focused on incentivizing architectures and platforms and structures for creation and innovation, even more than the back end, than the stuff that those things make. And it might favor innovation in the area of platforms and architectures even more than it favors stuff. I think it would really strongly reward information curation and knowledge management. I think it would encourage truth finding. And I think it wouldn't be a free-for-all, as I mentioned. It would pick the norms that work and enshrine them into something that's enforceable at a state level. And so that's my kind of foray into this thought experiment, and it excites me to be able to do it.
Thank you so much. That's perfect. I think I feel like there's never enough time. I was so absorbed in all of that conversation and discussion, but we do have 5 minutes. Maggie, if you wanted to respond or ask any questions, or if any of the other panelists or certainly anyone else who has anything to add or ask, please feel free. We have about 5 more minutes.
Oh, thank you so much, Shreyanka. And this has been such an incredible gift to me from start to finish. I really appreciate it so much. And, just having this piece workshop by 5 colleagues and perhaps more in the Q&A who have really thought so hard about values and things that align with my thinking around intellectual property over the years. This cumulative knowledge and wisdom is just amazing. It's just amazing. So that's really the only comment I have. I really need to let it all sink in because it's been so much, as Shreyanka just pointed out, you know, just sort of a fire hose of incredible ideas. I almost wish we could co-author something rather than me, you know, trying to assemble everything by myself. But thank you so much, everyone, for this. It's just, I'm going to keep this feeling with me for a long time, this wonderful feeling. I'd love to.
Can we jump
Maggie,
in?
would you mind telling us a little bit about your book, which is not just this chapter, but the whole project? We'd love to, I guess, hear from you a little more about that if you're ready to talk about it.
So the book is actually a co-edited book, and this is just one chapter in this book, and I'm actually not allowed to talk about it right now. But what I can say is that it's an A-trip book, and it will be published next year. And I think some people in this room know what I'm talking about, but I can't speak more right now. So sorry to pull the curtain over it, but I would love to hear what if other folks besides the panelists have any thoughts or comments to add.
Maggie, unsurprisingly, I would add that what you're talking about certainly has trade secret dimensions. And I'm grateful for what everybody said, because the paper I will be presenting in a little bit has similar themes. And I love the fact that these interdisciplinary conferences are just amazing. And, you know, I wish we weren't so siloed in our IP community, because something like this just allows so much learning among each of us about what everybody else is doing and thinking. And I really appreciate it.
Well, if no one else has a thought, oh, were you going to say something, Kaylee?
Yeah, can you guys hear me? Am I on mute?
Yeah, no.
Okay. So Maggie, first, thank you for coming. I mean, I think, you know, in life, you don't always get to see your babies, and a lot of us are your babies, right? Like your academic babies, that we wouldn't be writing the way that we write, and we wouldn't be thinking the way that we think if it wasn't for your scholarship. And the older I get, the more I recognize the people who have made such, given me such value in my life and my career, and you are certainly one of them. So thank you so much for being here. The second sort of notion I would say two things. First, I think that the freedom to operate, because it draws on a lot of philosophical traditions, also probably needs to be placed in a context too, in different historical contexts, as sites of struggle for different types of communities and groups. I did write an article on the IP clause as a constitutional norm. And one of the reasons why I did is I think judges resort to it as a constitutional norm when they're trying to figure out contested parts of IP theory, that we see judges intervene with so the norm is not a norm that's static, it's a dynamic norm. And that we see when judges are confronted with contests in the political economy of IP, they resort to it as a norm. And I think the freedom to operate also is like, and I'm sure you know this because there's critical race theory Maggie and IP Maggie, and it's subaltern, right? Like, I think you also have to contextualize it as it's not always the way in which elites would express IP, but that it's the way that all of us would express IP if we could, right? So I think that's something that's important to frame it as, that it's not that it's not only a site of contest, but it's the way that people who are locked out of the IP system express their desire to be in the IP system. So we could think about it as most IP is, like most information is free, right? But there's also a bunch of folks who might want their information to be locked up, right, for lots of reasons, but they also are trying to rethink the project of IP itself, and the freedom to operate language gives them space to be rethinking the project of IP as well.
I really love those comments, Kaylee. I love them as much as the other comments that have been offered. And I think what I'm going to have to do is substitute. I'll delete James Stern and I'll introduce Kaylee Murray's scholarship in one of the footnotes. So appreciate that so much.
I'm always seeking citations, but that wasn't the point. But I think it's just like one of those things where you're sort of just thinking through, like it's like, I have engaged with your scholarship in both IP and race and the law. And I think that the subalternity of the freedom to operate, to me, is something that's really important. There's always a set of I'll get off, but I'm thinking a lot about Alice Walker's story about quilting, right? Where there's the person who says, you know, the quilt has to be treated as a subject of IP. And in the story, the narrator says, no, there's a sister and she just wants to use it for everyday use, right? Like, so that she's trying to, as you would put it, have this freedom of operation and use, and she's thinking about it subconsciously against a sort of commoditized version of IP. And I think a lot about that story when I think about how IP functions in everyday life, but that's I think it's Alice Walker's everyday use, I think is what she calls it. And that's kind of a great story to think about the frame that you're setting now.
Okay, I think we've run over time. Thank you so much, everyone, for the comments. It was really such a great panel. I wish we had more time, but we have to move on to another great panel, I'm sure.